Good afternoon and welcome. I'm Giovanni Giarratana, and I serve on the Florida Bar 𝗖𝗹𝗹 Board of Governors as a representative for the 13th Judicial Circuit. And on behalf of the Florida Bar Young Lawyers Division, I want to thank you for joining us today for our 𝗖𝗹𝗹 Money Talk webinar series. So many of us young lawyers find ourselves overwhelmed by the debt that we have after law school and make critical career decisions that have long-lasting effects and put off some of life's biggest moments because of it. And that's exactly the issue the 𝗖𝗹𝗹 Money Talk series is meant to address. Through this series, it's our goal to provide practical knowledge and takeaways for the young lawyers of Florida to achieve financial wellness and success. Today is part one of the series, but also be on the lookout for parts 2 and 3, which will include topics such as how to balance tackling debt while also prioritizing and investing for retirement, and strategies on how to effectively advocate for yourself during salary negotiations as a young lawyer. As we move forward with this series, if there are any specific topics you would like to see addressed, please do not hesitate to reach out to me or your local representative. I'll put my contact information in the chat. The Florida Bar 𝗖𝗹𝗹 Board of Governors represents you, the young lawyers of the state, and we want to be sure to provide the resources that are most pertinent and relevant to you. And without further ado, it's my pleasure to introduce you to our esteemed speaker today, Christie Arkovich. Christie Arkovich has been a Florida licensed attorney for 30 years since graduating from Stetson College of Law with honors in 1992. Go Hatters. Ms. Arkovich is a frequent speaker at consumer-oriented continuing legal education seminars for the American Bankruptcy Institute, the National Association of Consumer Advocates, and the Tampa Bay Bankruptcy Bar Association. She also writes a quarterly column for the Tampa Bay Bankruptcy Bar Association titled Student Loan Sidebar, and maintains a YouTube channel for the Student Loan Sidebar, which gives updates about student loan-related laws, regulations, and developments nationwide. She recently served on the Student Loan Committee for the new Student Loan Management Program in the Bankruptcy Court for the Middle District of Florida, and was chair of the Consumer CLE for the Tampa Bay Bankruptcy Bar Association from 2019 to 2022. Whenever possible, including today, Ms. Arkovich takes the opportunity to share the knowledge she has gained about student loans from her prior work as trial counsel for Sallie Mae, ECMC, and other student loan servicers or guarantors, and now from her current practice on the consumer side. This webinar is sure to be cram-packed with some great information that you don't want to miss. If you have any questions that come up during the webinar, please put those questions in the chat. We have about 10 minutes or so reserved at the end of today's webinar to address as many of those questions as we can. And with that, I'll turn things over to you, Christie. Thank you.
Thank you, Gio. Thank you, everyone, for attending today. I know that student loans is a huge topic right now, and it was interesting that the Department of Ed just announced something that they said that student loans shouldn't be a life sentence. And that, unfortunately, is what it's turned out to be. So I'm sure that we have a lot of folks attending today that are not only young lawyers, but also of all ages. I recently wrote a chapter for a book, Elder Care Law 101, where we had a chapter for those who are nearing retirement or actually in retirement with student loans. So no matter what your age, I think this is very appropriate for you in trying to short circuit and understand what's been going on. And so without further ado, I do want to mention that things are happening rather rapidly. And so you're going to get a copy of this PowerPoint for any attendee by email. So don't worry about having to write down any of the links or things like that. But since things are announced daily almost, I mean, we had an announcement on the Fresh Start initiative this morning, for instance. So if things are coming out, the way to keep updated on that, rather than just reading maybe a news clip or a clickbait type thing, take a look at our YouTube channel. I try to do, now I don't have it initially right when the announcement is announced. It's usually within a day to a couple, 3 days later, after we've had enough time to digest, run it by colleagues and things, and see how to take advantage of these announcements. It might be new cases, might be new programs or updates to programs, existing programs. But this YouTube channel hopefully will have updates. We also, for attorneys, have this quarterly cram down, which is a student loan sidebar. It is available on our website, christiearkovich.com. Over on the right-hand side, you'll see cram down column. Click that and it'll go to the last one. If you're in the Middle District of Florida, where I am here in Tampa, the cram down obviously comes to all our emails and such. But do keep an eye on that, because what I say today could change tomorrow, actually. And so I'm going to go through the first couple slides very quickly. But the first thing that I want everyone to take away from this is don't take everything that your servicer says as truth. It's unfortunate, but your servicer is really nothing more than a debt collector. And in fact, Navient, at one time our largest servicer in the United States, said that there's no reasonable expectation that we are working on behalf of the borrower. Our client is the creditor. So it's important that you understand what your loans are and what to do with them, or have an advocate that represents you. Don't rely just on your servicer. I have our clients test that regularly. I have them call their servicer 2, 3, 4, 5 times. They're going to get more than one answer. The problem then is maybe that answer is correct, but which one was it? And that is the problem that's out there. There was an Inspector General report that I always like to cite to that we used when our Middle District of Florida started a new program, student loan management, to deal with student loans in bankruptcy. And this Inspector General report found that 61% of the time, a federal student loan servicer wasn't doing something correctly, whether it was telling folks what their options were, whether it was calculating interest, putting them in programs, whatever it is, 61% of the time, they weren't doing it accurately. Now, if I didn't follow the law 61% of the time, I'm pretty sure the Florida bar would have something to say about that. And I'd be lucky if I wasn't disbarred. But we're not seeing that kind of oversight from the Department of Ed. At least we haven't in past years. Maybe going forward, we will. We are seeing substantial changes with the Department of Ed, and that's what I'm talking about today, is some of those new programs. But it's important that you understand your options. Don't rely strictly on your servicer. Now, when I have a client come in and see me, and I know that most of the folks attending this webinar are probably here for your own student loans. But if, for instance, you want to start practicing in this area, the first thing, and you should also look at this for your own loans, is what do you have? How much is private? How much is federal? A lot of folks say that they consolidated their loans, but federal and private are never consolidated together. Private is always separate. And so you want to know, what did you take out? Whether it was a Pell Grant, do you have to repay it? Is it an older loan, a newer loan? Did your grandparents or parents take out loans? Did you take out loans for your kids? Gather them all together so that when you address your student loans, you're addressing all of them. During the pandemic, we had an extraordinary amount of people that didn't know the difference between the different type of federal loans. You have the older loans called FFEL loans, Federal Family Education Loans. They basically were discontinued in 2010, but prior to that time, 80% of the loans were FFEL loans. The thing about FFEL loans is that they're originated by a private party, and they're often held by a private party, usually a commercial party. And so they don't have the same governmental protections as a direct loan, which is issued directly by the government and owned directly by the government. That's what the name direct loans is standing for. And so when COVID occurred and we had the CARES Act, which was passed in March of 2020, I believe, FFEL loans didn't get the same protection as direct loans. They maybe didn't get 0% interest. They maybe didn't get forbearance for an extended time. And because of that, you had folks that believed that their federal loans were put in this pile over here where they didn't have to touch them for a while. And instead they've defaulted. And so that disconnect is huge during the pandemic. We've known of it for years. FFEL loans are not eligible for a lot of different programs. And one of the things we're going to talk about today is why you might want to consider consolidating an older FFEL loan to a newer direct loan to take advantage of some of the fixes that have been passed within the past year to programs that weren't working so well before. And that would be public service, that would be the extended forbearances and things like that. Now, in looking to see what kind of loans you have, how do you find out? Well, first of all, the federal loans are all on a nice, clean database. It's actually pretty easy to find them. You just have to know where to look. So if you go on studentaid.gov, you go to, I believe it is log in. You have to type in your username and password, FSA information, view details, and download my aid data. That's the button you're looking for, is download my aid data. It doesn't really sound exactly like what you might want to be looking for, but that's what the link will tell you. Download my aid data. It'll go directly to your NSLDS report, which is the National Student Loan Database report. If you'd like to see screenshots as well as some things about downloading the PDF and things, on our website, ChristieArkovich.com, on the Contact Us page, we have a link that shows a number of screenshots. I think there's about 10 or so showing what to expect, and here's how you get that information for your federal loans. For private loans, it's more difficult. There's no database. And so you have to look at your credit report, mail, phone calls, things like that to try to find out what you might have for private loans. But again, they won't be consolidated. They will always be separate. And most of our conversation today is going to be about federal loans. The reason for it is because most of the programs out there right now are all addressing federal loans, and the restart, which is currently scheduled at August 31, is for federal loans. So that's what most of today's topic will be. But we're going to cover some of the things that you might want to look for and things to get ready for that restart time period. First of all, forbearances. I always want to talk briefly about that. We've had a number of folks, including attorneys, that have been on extended forbearances. And that might be where you've had issues where you haven't been able to get a good enough paying job, haven't been able to find a job, have a number of other expenses and things that you couldn't make a student loan payment. Unfortunately, what happened over the past 10 years or so is folks who had difficulty making a student loan payment would call their servicer. And the servicer, some servicers allegedly had customer representative incentive programs where they got paid more for short call durations. So how do you get a borrower off the phone quickly? If you're a call center rep and you want to make more money that week, how do you get that person off the phone quickly? Well, you give them a forbearance. It takes virtually no time at all, no paperwork. The borrower is immediately satisfied. It was easy to get, and there's zero payment for probably a year. The problem with forbearances is that it was not a fix. It had a snowball effect. We had growing loans. The navient was estimated by the CFPB, and this was a few years ago, that $5 billion had been unnecessarily added to the student loan debt amount because of these extended forbearances that really the person should have been placed in an income-driven plan. What income-driven plans are, for those who don't know, is it's basically, and there's a few of them, a lot of acronyms here, but they're called income-driven plans. Think of that as an umbrella over a series of different ones. You have ICR, ISR, which is really no longer active, but I still see them once in a while. IBR, repay, pay, IBR for new borrowers. Those are the types of income-driven plans. And what an income-driven plan is you submit your income information. The payment is based on a calculation of 10 to 15 to 20% of your discretionary earnings. Never takes into account what your actual expenses are, but it uses the national average to figure that out. And so the key about income-driven plans is at the end of them, you have forgiveness. So anything that remains owing, whether it's principal, accrued interest, whatever it is forgiven at the end, and maybe taxed, maybe not, depends on which program you're in. And those programs last either 10 years for public service or 20 or 25 years for non-public service folks. And so if you have a person who's chronically underemployed, they're basically not making enough to make their student loan payments as well as maintain a minimal standard of living, then they should be income driven. That way they have that forgiveness, but we don't have that with forbearances. And so one of the fixes I'm going to talk about today talks about how we are eliminating forbearances and we're trying to fix some of the problems that was created by that. But lastly, you want to know, figure out a plan. Where do you want to be 10 years after graduation? We have had a number of folks who they're 10 years after graduation and they haven't made a dent in their student loans. They thought maybe they were in a 10-year plan, but most of the plans more recently have been 20 to even 30 years. When I graduated law school back in 1992, I believe, most loans were on a 10-year plan. Nowadays, most are on 20 to 30 loans, or 20 to 30 years, sorry. So real quickly, the Biden administration has undergone a number of different changes with student loans to try to give forgiveness without relying upon Congress. But Congress has played a role initially with some of these things. The biggest thing is the American Rescue Plan that was passed initially back at the beginning of COVID, allowed for the waiver for the taxable event for all debt forgiveness of private as well as federal student loans, as long as it's done before December 31 of 2025. Now, I like to have our private student loan settlements, the last payment made before the end of 2025, because I believe that the 1099 would not be sent until the last payment is made. The reason for that makes sense. You have a settlement agreement, you have payments. At any point, if that person were to default, then of course the debt would roll back to where it originally was, minus payments that were made. So I think that it's important that you try to, if you have a private student loan settlement out there, you try to make sure to maybe make a balloon payment of the remaining payments that you have under the plan, whatever it is, to get it done before the end of the year of 2025, because you won't get a tax bill. That tax bill could be substantial. Most of our student loan work that we deal with, we're talking about loans that are well in excess of 10 and 20,000. We typically have between 50 and 300,000 for student loans that we're dealing with. So if we can settle those for a third or so, say a private loan, that means a tax bill, it could come on 60-some%, which would be substantial. So we want to make sure that we try to hit that, that taxable event if we can. Now, for federal loans, if anyone gets a discharge through the disability program, through public service, anything like that, you're going to get tax-free relief as long as it's done before 2025. I know one of the things that is talked about a lot right now is universal debt cancellation. We have proposals anywhere from 10 to 50,000. There's not a lot of support for out there for $50,000, but there is quite a bit of support for a $10,000 across the board universal forgiveness. It may be income capped, it may never occur, but if it does, you might want to think about waiting. If you are thinking about privatizing your loan for reduced interest, you might want to think about waiting a few months, because if they're going to do it, they're probably going to do it in the next few months. And it is something that President Biden wanted to have done through Congress, both houses. So we don't really know what to expect there. I won't spend too much time on it because, again, it's something that we expect in the near future. The payment pause per the CARES Act has been rolled over and extended a number of times. The last extension expires in August 31 of this year, in just a couple of weeks. We've not heard that it will be continued. This is the closest in time we've gotten. Generally, when they've announced an extension, it's been about 40 days out in the past. Now we're down to 2 weeks. I'm not sure. I've heard things from both sides that it may be extended and that it may not. My problem if it's extended is this. If we don't have a payment restart date, August 31, and it's bumped to the end of the year perhaps, some of the fixes that have passed in this year are going to expire before then. Public service loan forgiveness has a deadline, October 31. We're going to cover that in a second. Anyone who has extended forbearances in the past, you're going to get credit for that now, but you got to do something before December 31. So these two things, October 31, December 31, they're going to pass. And so if we have the pause extended once again, I fear that people are going to put their loans aside, not look at them, and these deadlines are going to pass. That could be critical because we see every day people get full discharges under these new fixes. And next year, they're not going to be able to take advantage of that. So I fear for that. If anyone out there has loans still in existence, have friends with loans still in existence, especially for public service, please reach out to them. Let them know that there's something they need to do. They need to consolidate their older FFEL loans to direct loans before October 31. If they don't, they're going to miss out on some major stuff. Now, the IDR waiver, what that program is first of all, it was announced in April of 2022, and it is an attempt to fix the extended forbearances that were out there. And so basically, if you have a forbearance that has lasted more than 12 months, and that would be consecutive or 36 months cumulative, in other words, you had piles of forbearances here and there, make sure that you also consider consolidating your loans to direct to make sure that you get credit for those time periods. We've had folks that have been on forbearances for many years, somewhere between 5 and 10 years. They would never get credit for that in the past. But because of this change, this guidance basically that was passed in April of 2022, as long as they consolidate their loans to direct so that they're owned by the government, they're going to get credit for those extended years of forbearance. That's something that's never happened before. And it's a one-time fix. It won't be continued. And so don't let that pass. The Borrower Defense Program, we're going to talk about that a little bit more. Awesome program. There's been a recent settlement that I think 𝗖𝗹𝗹 versus Cardano, that is something that people who attended certain schools are really going to want to take advantage of. So how do you know whether your loans are set to do the right thing, or do you need to do something about them? The first thing I look at is if your loans were taken before 2010 or after 2010. Remember earlier I mentioned that the 𝗖𝗹𝗹 program was discontinued in July of 2010. That means that any loan taken after mid-2010 is going to, by necessity, be a direct loan, any federal loan that is. And any loan before that, 80% were 𝗖𝗹 loans. If you did a consolidation back in, say, 2005 to 2008, shortly after graduation, anything like that, those loans might be a 𝗖𝗹 consolidation. Unfortunately, we had folks that had applied for public service believing that they had to do a consolidation, but they had done a 𝗖𝗹 consolidation, so they weren't eligible for public service. They'd have to start all over again. The public service program out there, the fix, kind of fixes that. But essentially what you're looking for is if you took loans out before 2010, you're going to want to look at them because you're probably going to need something to do something to make sure that you get credit. If it's after 2010, you probably don't need to worry about it. Your loans will have to be federally direct loans, and you're already kind of set for the public service loan forgiveness waiver. You're set for IDR waiver. You're set for any universal debt out there forgiveness. You're also set if they come up with a new income-driven plan, which they are expected to do in about 6 months, and it probably will be a little bit lower than the lowest one right now, which is known as repay. So if you are, if your loans are after 2010, you're probably in good shape for that. But I still want to talk with you about borrower defense and some other things. Now, what can you do if your loans don't qualify? Some people think that once you have a loan, you can't ever change it. You always have that loan. You have a master promissory note you've signed. There's a copy of it running around out there somewhere. You can actually change it. A consolidation is something that people think of, you're taking a pile of loans and you're combining them to one loan. But there's a lot of different reasons and a lot of different things people do consolidations for. One of them is to change the loan types. You can take a parent plus loan and you can make it a non-parent plus loan. It takes a couple of different consolidations to do that. It's a weird process. Remember I mentioned earlier, you could take a look at our YouTube video. We did just publish a video a couple days ago about a way to take a parent plus loan and drop the payments in less than half by doing a double consolidation. It removes the designation of parent plus. So with consolidation, you can change your loan types. You also can cure a default. Right now, this morning, there was a packet of information out of the Department of Ed talking about the Fresh Start program. It will change some of the things about restarting a loan when it's in default that previously existed. In the past, in order to cure a default, you had to do what I call is 2 get out of jail cards. It's kind of like Monopoly. You rehab, which you can do one time, and you consolidate, which you can also do one time generally. There are exceptions to those, but for the vast majority, you're limited to those one-time only things. And so those get out of jail cards, once you use both of them, there's nothing else you can do. But this Fresh Start initiative will allow people to cure a default that might have existed before the CARES Act in a way that will help their credit and help them be able to purchase a home by not being on the CAVRS report, as well as other things. So the other thing about consolidation is that a lot of folks think that it exists to lower interest rates, that you consolidate to a new lower interest rate. The problem with that is that consolidation is a market-weighted average to what it was before. If you had 7 notes before at different interest rates, it's an average of those based on the amount of each loan. And so it really isn't for that purpose. It's more to cure defaults and change loan types, get all your loans with one servicer. That's a huge advantage. One of the biggest problems that we have with clients out there is we have folks that have 3 different servicers and they have different loans with the different servicers, and some are in default, some are not. They're getting bills for some, they're getting, it's just kind of a mess. So sometimes combining them all and curing the default, putting them with one servicer, makes it a whole lot easier. And so when we have a client come to us with student loans, our goal is to put them in the best program going forward so that they can just set it and forget it and not have to worry about something in the future. So we do a lot of consolidations because it eliminates a lot of problems, basically. With borrower defense, there's a bit of misinformation out there. We've heard two different versions of whether you need to consolidate an older FFEL loan to take advantage of borrower defense. I think it's safer to do the consolidation because the guidance is unclear of whether it's necessary. The Department of Ed has some language on their website saying it is not necessary to consolidate a loan to take advantage of borrower defense, but some information in the suite settlement states that it is. So if there's no harm in consolidating, you might want to think about it just to be on the safe side. And then lastly, if there is any universal relief, typically before the last couple of fixes, most everything the Department of Ed passed was always eligible, was only available for those with direct loans. And the reason is because direct loans are owned by the government, so they therefore can affect the terms and conditions of that. A private loan, not so much. A privately originated federal loan that the federal government backs, insures, basically, but doesn't own, not so much. And so some of the programs out, like public service loan forgiveness, for instance, only applied to those with newer direct loans. The repay program, the 10% program, which is the lowest possible payment that someone can have on their federal student loans, was only available for, you guessed it, those with direct loans. So lately, the last couple of fixes have been broader than that. They're affecting FFEL loans as well as direct, because this particular government recognizes that there's a distinction that's without a distinction. A federal loan should be a federal loan, and that's where it's coming from, and that's why they're trying to have these fixes apply to those that have the older loans that don't get the benefit of some of these newer things. So what is this public service loan forgiveness waiver? I did want to mention that last December, we did a 1 hour seminar specifically on this program. So while I'm only going to spend, a couple, 3 minutes on it today, if you want a whole hour on some of the ins and outs, go back and watch that. It was, it's on the Florida Bar webinar. It was December of 2021. So what it is in October, in late October, they announced that the abysmal approval rates for public service loan forgiveness, which was, I think it's like 1%, 99% who applied were not getting the forgiveness that they had relied upon year after year. And so they put this fix, this public service loan forgiveness waiver program into effect. And so they gave it a deadline. It's 1 year from the date that it was passed. So we have a deadline now of October 31, that if someone wants to go back and try to get credit for any past payments, and this would be late payments, if they made the wrong amount, if they were paid ahead status, a teacher, for instance, often paid ahead for summer months and things, if they were on the wrong plan. A lot of folks were on extended or graduated. They weren't on an income-driven plan. Those payments never counted towards public service because public service loan forgiveness only counted income-driven plans. Or maybe they had the wrong loan type, which is the older FFEL loans as opposed to the newer direct loans. So any problems with past payments are going to count. Interestingly enough, with the forbearance IDR fix that was announced a few months later, which I'm going to cover here in a couple minutes, any extended forbearance periods are also going to count. So when you combine all of that stuff, you have someone who previously would have been denied for a public service loan forgiveness, which for those of you who don't know, it's basically 10 years of payments, 120 payments made timely while you're working public service, which is 30 hours or more, working for a state, local, or federal government. You don't have to be a teacher. We still have folks out there that think this is a teacher program. It's not. You can be doing anything for this entity. It can also be a nonprofit, a qualifying nonprofit. So there's certain areas of business, education is one of them, healthcare, there's a whole list. There's also a public service loan forgiveness help tool on studentaid.gov that someone can type in the tax code of their entity to see if they're eligible. You also can send in the form, the certification form, public service loan forgiveness certification form, and they'll shoot back a letter that states that the entity is eligible or not. But basically, anyone who'd made payments in the past are now going to be eligible for public service. This counts for someone who is now working privately. The public service loan forgiveness program, when it was first passed, did not count someone who wasn't still working at that government or nonprofit at the time that they submitted their application and when it was approved. Now, with this fix, you don't have to be working there. So I've talked with folks who are attorneys now. The last one was general counsel, where he had given up on his loans a long time ago. He owed so much, he kept just forbearing it, over and over and over again. And when I got a hold of him, his friend basically made him reach out to us. We realized that he's eligible now. He just needs to submit the right thing and do the consolidation to make his loans eligible under direct loans. And he'd given up. And unless someone had reached out to him, he did not know that this fix had even passed because he had blanked out everything. He just didn't want to talk about student loans anymore. They were so frustrating to him. So do me a favor, reach out to anyone who's in public service that you know, see if they have loans, make sure they know of this fix. There's still people out there that don't know of this fix and that they know what to do, and they know of that deadline of October 31. Now, interestingly enough, it also applies to any pre-consolidation payments. Generally, when you consolidate a loan, you have a new loan that pays off the old loan. And so you don't get anything that happened with the old loan. It doesn't transfer with the new loan. So in other words, you would lose any time that you accrued towards forgiveness. That was a major problem because you might have folks that have 4 years pre-consolidation. Do they want to lose that by doing the consolidation? Well, with public service, with this loan fix, you don't lose that time. And so there's no harm in consolidating to a direct loan to get credit for that. Federal loan payments count. It's automatically calculated for military and federal employees, not for state and not for public nonprofits. So you have to consolidate your loans and you have to file a public service loan forgiveness application. There's not a particular deadline for the application. There is a deadline for consolidating your loans. They are going to automatically review previously denied applications. If you have any concern about whether you filed one, you're not sure, file one again. There's no harm, okay? So just make sure you get credit for this. Now, I mentioned briefly the IDR waiver. This is the thing to address the forbearance. Remember I mentioned that servicers would point people towards forbearance because it was the easiest way to get someone off the phone. So the new procedures by the Department of Ed is to eliminate that process and avoid forbearance steering. What it's also designed to do is to correct the past problems and have a one-time fix for those who were in extended forbearances and allow credit for that. When loans were in repayment for 20 or 25 years, and the 20 or 25 years is dependent upon which income-driven plan you're on. Remember, I mentioned there are different percentages and there are different lengths of time also. Public service is 10 years, IBR is 25, ICR is 25, repay is 20 years as well as pay. So sometimes it's between the 20 and 25 years. If your loans have been in repayment for that period of time, then you're going to get an automatic forgiveness. Now, if your loans have been in default, you're probably not going to get the benefit of any of this. The deadline to consolidate to direct loans to take advantage of any extended forbearances is December 31 of 2022. There was an estimate out there that basically 200,000 borrowers may be eligible for this. Most of us believe the number is far, far higher than that. And the reason why is because virtually everybody I talk to has been on an extended forbearance. And that's way more than the 200,000 that they are currently reporting. And interestingly enough, you can combine this with the public service loan forgiveness waiver. So you can take all your payments, you can take all the forbearance periods. When you combine them together, 10 years is a no-brainer. Most people can get to that very quickly. You also can, let's say you're a year or two shy, you get credit for all that time, then we can go ahead and you can work for a nonprofit. Doesn't have to be consecutive, so you can go back to work somewhere or another, finish out the remaining months, and then get your tax-free discharge. With public service loan forgiveness, it's tax-free, the discharge, regardless of whether it occurs before 2025. Anytime, it's always tax-free. There was something that was announced, it was announced, I forget exactly when, a couple months ago, but the guidance just came out this morning. And it's for those primarily who were in default before COVID. It's called the Fresh Start Initiative. The name is a little bit confusing because it also matches with the Fresh Start that we get in bankruptcy and the name of an act or bill, basically, that is running through Congress right now, also named the Fresh Start Act. But essentially, for those who were in default prior to COVID, Generally, I mentioned before that there's two ways to cure a default. You have to rehab or you have to consolidate. Right now, they're allowing people to go into a streamlined system where they're designed to be current and can enter into an income-driven plan almost immediately. It's not going to be automatic. We thought at first it was going to be automatic, but it's not. You have to visit myeddebt.com. I'm sorry, it's right on here on the screen. myeddebt.ed.gov. That thing I just heard of this morning, so I don't have it really in my brain yet. It's kind of a weird name, myeddebt.ed.gov. Anyway, you can also call the default resolution group. That's the portion of the Department of Ed that handles loans that are in default. And you have to, and the 1-800 number here is on the screen. You have to ask for your loans to be transferred to a non-default servicer. The default resolution group doesn't have the system in place yet for this. I don't know how many days or weeks it might take. I hope they can get it in just a matter of a day or two. But you want to transfer your loans to a non-default servicer as opposed to a debt collector, which is what default resolution group is. At that servicer, then you can go into the income-driven plans and things like that. The Fresh Start Initiative is also going to allow 1 year for people to do this, and that during that year, there won't be any collection efforts. There won't be tax refund seizures or interceptions, basically, and there won't be Social Security offsets. Right now, when a loan is in default, 15% of someone's Social Security can be taken, their tax refunds can be taken in whole, minus an injured spouse portion and so forth. So that 1 year reprieve on collections, you've got a whole year to do this. There's really no reason not to do it earlier, though. They're also going to not allow for loans in default to report on someone's credit as they traditionally have been. They also have already removed everyone from the CAVR system. Now, that's important if you have been looking at buying a house. If you've been denied for purchasing a home, it's probably because you're on that list. A loan in default automatically will go into the CAVRs list. That's automatically checked by all mortgage, not servicers, but whatever they're called. So right now, that's clean, very clear. I don't know what it's going to take to get back on that list. Probably if the 1 year passes and someone hasn't gotten their loans in repayment, I imagine then they're going to roll over to, again, credit reporting, collection calls, tax interceptions, the CAVRs list, and things like that. But it won't happen for next year. Anyone who has rehabbed during this year, or during COVID, I should say, in anticipation of getting their loans in place, the nice thing they're going to do is restore eligibility. Remember where I mentioned you can only rehab a loan once? Well, they're going to eliminate that for anyone who is rehabbed during COVID. So that's nice, because then if you happen to default in the future accidentally, you'll get another chance to rehab. Probably won't be that important for everyone, but I imagine that there are some folks who will want to take advantage of that. There is some new proposed regulations that will be coming out. They're in the comment period right now. They're talking about arbitration, the borrower defense program. They're doing some streamlining. Basically, there's not going to be as much interest capitalization in the future as there is presently. They may remove the income monitoring for those with disability discharges. We'll talk about that here in a second. These changes will all take place, I believe, before July of next year. Now, the borrower defense program, we have about 20 minutes left, so about 10 minutes before questions. The borrower defense program is something that most people have heard of, but not everyone. Essentially, back in the mid-90s, there was a couple lines that Congress had passed, and it basically said, hey, if you have been the victim of any false representations by your school, there is a way that you can defend against a collection action by asserting that as a borrower defense. And that's all it said. It was only 2 lines, didn't really say anything. So we had Corinthian and Everest basically collapse. A lot of folks started to email and try to file paper, not applications, but letters and things with the Department of Ed. So the Department of Ed created 700 some pages. I remember reading it on my patio a few years ago. Most boring reading I've ever done. But this program was announced that would deal with folks who went to generally for-profit schools that didn't get a benefit, that they were misled, they were overpromised, usually with job placement rates, salary ranges, accreditation, transfer of credits. Usually the schools would represent a certain thing, and it turned out that that was never ever true. That program has gone through a lot of changes. Initially, we were starting to get approvals. Those during the Trump administration had turned into denials and also just holds. So there were some class action suits filed. One of them was called 𝗖mě versus Cardano, and they had a class action settlement that was announced June 22. And so as a result of that, there's this extensive list. If you look on our blog, and it's on our website, ChristieArkovich.com, we have a link to the list. The list has had a little bit of revision since to clarify a couple things, but most of the schools are still on that list. There's over 100 some schools, including 2 law schools and many undergrad schools. And so it's important to get your application in. Anyone who had an application in before June 22 will usually get or is expected to get a full discharge of their student loans or refund of student loans that they paid if their school is on that list. For those who submit an application after, there is preferential treatment, primarily with respect to the review period. We also believe that if you file an application after June, you probably, if you're one of the named schools, while it won't be automatic, I believe the Department of Ed has telegraphed that these schools are problem schools, and that as long as you say the right things in that application that fit within the evidentiary type things that they've already come up with to be on that list in the first place, they're probably going to get cancellation. It just will take a little bit longer. The important date now is November 2 or 3. I think it's November 3 is the final hearing. So we had a interim hearing that was, I think, August 4. And as a result of that, there's going to be a fairness review period and things like that, a time period for people to submit objections and things of that nature, and then the final hearing to approve. The judge already indicated the preliminary approval, but the final hearing is November 3. So if you haven't filed a borrower defense application yet, you need to get one in before November 3. The earlier the better. You certainly don't want to wait to the last minute. It is rather extensive when you file it, but you just go through and answer the questions. On our blog, we have some information that you might want to look at before you file it on your own, just to save yourself some time in doing so. There's some links here for some further information, including the school list and things of that nature, but it's not automatic. You have to file a borrower defense to repayment application. Now, I'd be doing a disservice if I didn't talk about total and permanent disability discharge. I know that I'm speaking here today to maybe mostly younger lawyers, but I'm sure there's a lot of folks who are older who are also listening in. And this doesn't necessarily mean an age thing, but the vast majority of our clients who come to us are generally in their 50s and 60s, and they have some kind of medical condition that prevents them from working. Maybe they can work a little bit, but they certainly can't work full-time doing what they used to do. We have an occupational medicine physician that works with us to file these applications, and we have not been denied one yet. And I think that is an awesome record. I imagine that at some point we'll lose that, but the program is very successful. And it's also very fast. The applications, when we file them, we generally receive a response. And when I say response, not just a, hey, we've received your application, but an actual approval of a full discharge of our loans within 1 to 3 months. So it happens very, very quick. Now, it's not required for everyone. If you already have been approved of 100% VA disability, or you're on Social Security disability, it will be automatic. And that's one of the provisions that have been passed the last year to make it automatic for those most deserving. But we run into a lot of folks who they haven't been approved for Social Security disability. That process is often 3 to 4 years as it is, or they've been denied. And so our process looks at their real vocational abilities. And I used to do a lot of employment law, working with the FMLA and ADA and things. And I'm very familiar with the reasonable accommodation requirements of an employer. And so we focus on usually cognitive type disorders because an employer simply usually can't accommodate that. With today's remote work, I think that a lot of things can be accommodated, but the inability to remember or do different things is something that just can't be accommodated no matter where you're doing your work. The thing in question is the 3-year post-discharge monitoring. Right now, there is in place a provision that says, okay, well, once you get the approval, which happens in 1 to 3 months, there'll be a 3-year income monitoring where you're supposed to send in your tax return. As long as your earnings from employment are less than $17,000 and change, the denial will stand. If not, the loans will be reinstated. That monitoring has been suspended during COVID, and there's a request by the Department of Ed to eliminate it entirely. But that's part of the decision-making right now. We don't know if that's going to ultimately be approved. It probably will be, but you just never know. So I have counseled folks to, try to focus on things that maybe enhance their career if they still are working or doing some kind of self-employment, but maybe not something that makes a lot of money if they're getting close to that the end of the 3-year period. But don't forget about total and permanent disability discharge. It is an application that must be filed. It's not something that's automatic unless someone is already on Social Security disability or VA disability. Now, real quickly, before we open it up to questions, I did want to just mention with bankruptcy reform, I used to represent a number of the servicers in bankruptcy. I ran around the state of Florida and represented those clients in trials and things. And it was very difficult to obtain a discharge for the opposing party in bankruptcy because they couldn't show an undue hardship. And the primary reason for that was an undue hardship is something that is very difficult to show in the future. You basically have to allege and prove that for the majority of the repayment period, which is a 10 to 20 year time period, that you won't be able to work. And to prove that in the future is hard to do. So those cases are expensive, they're time consuming, and this is one of the things that bankruptcy reform is looking at changing. The current standard is the Bruner standard. I won't go into that today. It's kind of outside the focus of this, but it basically has 3 prongs of whether you've maximized your earnings, minimized expenses, and made a good faith effort to repay. Again, that standard is very, very hard to meet. And I think reform is necessary. What it's going to look like, we don't know. There is a Fresh Start bill out there right now that's trying to bring it back to a 10-year time period. When I graduated in 1992, that was kind of what it was, is 10 years. Maybe it'll settle around 15 or so. Even that would be great because we're seeing folks out there now with 30 years of loan repayments. And they're nearing retirement and they still have loans, their own loans, not even loans that they've signed for their kids, but their own loans. It also is intended to be more automatic, where you wouldn't necessarily have to prove the undue hardship. It would hurt someone's credit to file a bankruptcy, and the advocates for that bill think that that is sufficient to have the regular bankruptcy review period act as the undue hardship. And they also want to increase the institution accountability. That's something that is being addressed with borrower defense program as well. If you're going to forgive all these loans, how are we going to stop for-profit schools from doing it all over again and from pocketing the money that they gain off of the backs of the students and the government? This is the standard that exists currently. It's not changed yet, but maybe that Fresh Start Act will go through this year. So to recap real quickly before we open it up for questions, anyone who has federal student loans right now, you need to look and make sure that you have direct loans as opposed to the older FFEL loans. If you happen to have any Parent Plus loans, there are some issues regarding consolidation. Reach out to us. Make sure you learn a little bit more about why you should consolidate and how to consolidate a Parent Plus loan. They are a little bit unique. If you don't have direct loans, then please consider consolidating them before the end of the year so that you can get credit for any forbearances that you've had in the past, as long as they meet the definition. If you're public service, make sure that you meet that 1031, October 31 deadline, so you can count all those payments that have been denied. And trust me, there's been tons of payments that have been denied. So that's a very worthy fix. And then lastly, if your loans have been in default prior to COVID, be sure to transfer your loans to a non-default servicer for the fresh start. You have to actually reach out to Default Resolution Group to do that. But once you do, you'll find that your credit reporting will be much better, and you'll short circuit the process to get out of default to enter repayment. And then lastly, if we are going to get some universal debt relief, it's important that if you're considering privatizing your loan, taking your federal loan, going out to one of the private student loan servicers, that you see if we're going to do universal debt relief before that. It may only be $10,000. It may not make much of a difference. Also, with the interest rates going up for federal rate right now, as well as interest rates for federal loans going down for recent grads, you may find that privatizing a new loan right now doesn't make any sense because the interest rate savings doesn't exist. Usually privatizing a loan that's been 10, 20 years ago is well within your interest, because the loans are 6.8 is a national average, for instance, and a private loan is 3 or 4%. But as you narrow that gap, it's not going to be worth giving up the federal guarantees and things that you have to privatize a loan. These are some additional resources. The studentaid.gov repayment calculator will look and see, will help you in determining which income-driven plan might make sense. What it doesn't do is tell you how you could change it to make it better, but it will tell you what your loans are eligible for as they stand. The Ombudsman Office, we use them sort of as an extended appeal type office. They basically are staffed with more educated individuals that can give you more accurate guidance. Plus, they have access to all of your different servicer information as opposed to just one segment that might be with one servicer. And the NCLC always has some good materials. Here's our information. Importantly, we maintain these student loan sidebars that we have, again, in the Cram Down Quarterly, which is a written publication. It's available on our website at christiearkovich.com. Go over to the bottom right-hand corner, you'll see Cram Down Quarterly. We write a column. It's usually 1 or 2 pages for our local bankruptcy publication, telling attorneys what has happened with student loans in the last quarter and how their clients can take advantage of different things. We also have our YouTube video that we also put out regularly, much less than quarterly, usually weekly or so, thereabouts. It's pretty much after there's been some change. So keep an eye on that, if you will. I think there's a lot of good information there. And I believe that's it. Gio, if we have any questions come in, let's spend a few minutes on that.
Do we have questions, Christy? We certainly do. There's a lot of questions, and unfortunately, I don't think we're going to have time to address all of them. A lot of them, though, just to give peace of mind to those who may have missed some information, this will be posted on the Florida Bar YLD website for your reference later. Just be on the lookout for it in the next couple of days. And also, Christy has graciously agreed to share the PowerPoint presentation to those who attended today. So we'll be sending that along to you as well, so you can reference the information. So one of the questions that came up, there's a lot of great questions. One question was about the graduated payment plan, and if there are any benefits with a graduated payment plan, such as loan forgiveness after a certain period of time, and if you could address that.
Not currently that I'm aware of. What the graduated payment plan is it's usually both graduated, in other words, it stair steps up every 2 years, it resets with a slightly higher payment. It's also for an extended time if it's extended graduated. The regular graduated is 10 years, the extended graduated is anywhere from 20 to 30 years. Currently, there's no income-driven aspect to that. In other words, there's no forgiveness at the end. So you would want to switch to income-driven if the payment is comparable in order to get forgiveness at the end. It all depends on your timing, though, because graduated is a 10-year program. The income-driven plans, unless your public service, is usually 20 or 25. So just take a look at those numbers and see if it makes sense for you. But there's no forgiveness at the end of, well, with graduated, you're paying the loan off. I guess I should say it that way. At the end of 10 years, your loan payment is paid off. So you may find a different income-driven plan makes more sense for you with forgiveness.
Thank you for that. The questions keep on coming in. Here's another one for the DTR. If you get your loans canceled, does your degree get invalidated? Does your name end up on a list that the public can see that you got your loans canceled under DTR?
I haven't heard of a list. I have heard of that concern, and that's being addressed now. We're not sure, but the final hearing will probably address that a bit more. Currently, the borrower defense program does not require anyone's transcript to be held or pulled back or anything like that. But the Sweet versus Cardano settlement does have that provision in it. We don't know if it's going to survive to the final hearing, so just wait till November 3 to know for sure. If we have someone who needs that transcript, sometimes we recommend public service forgiveness or an income-driven plan to be safe, because borrower defense could very well leave that in with the class action settlement.
Okay, I think we have time for maybe one or two short questions. If you were in repayment prior to COVID, but have not been repaying during the COVID pause, does that qualify as a forbearance that needs filing before the deadline?
Actually, the CARES Act provides that any forbearance during this time is going to count. None of the other fixes were really necessary for that. That includes public service as long as someone was actually working. So if you were on leave and not working, that forbearance won't count towards public service. But if you were working, like I mentioned, full-time, at least 30 hours or more, you would get credit. Anyone in private service will definitely be getting credit during the COVID time for any forbearance. There's nothing they need to do for that, as long as their loans were direct under the CARES Act. And if you happen to have a FFEL loan, you can always retroactively fix that. Remember, you can consolidate to a direct loan by December 31, then you'll get credit for extended forbearances. So let's say, for instance, during COVID here, you've had a FFEL loan all this time. You might want to seriously consider consolidating to direct loans before the end of this year. You'll get then the credit for forbearance that you would not have gotten because you didn't have a direct loan during COVID.
All right, well, I think that is all the time that we have for today. Christie, I want to thank you again so much for imparting your knowledge. That was so much information that you were able to break down for us in a short amount of time. And I greatly appreciate you providing and being a resource for us young lawyers and being here today and giving us these critical updates from the Department of Education.
No one lose hope. There's lots of things out there. You just have to know what they are and take advantage of them.
Yes. And thank you again to everyone who's joined us for part 1 of the 𝗖𝗹𝗹 Money Talk series. Again, for anyone who's interested, the webinar was recorded and will be available on the Florida Bar 𝗖𝗹𝗹 website in the coming days. This course is also, you can also receive CLE credit for this course. The code information to those who attended today will be sent via email after we conclude. And again, Christie has generously offered for us to send a copy of her PowerPoint to you as well. So look for that in your inbox. We hope to see you for parts 2 and 3 of 𝗖𝗹𝗹 Money Talk coming soon, and have a great rest of the day, everyone.
Thank you.